Je to trošku neostré asi, ne? Dá sa s tým čo robiť, či? Tak niekde behal včera.
Máme ten kolega jeden. Dobré ránko, dámy a páni. Good morning, dear ladies and gentlemen. Hneď na začiatku vás chcem informovať,
Good morning, ladies and gentlemen.
vznikli menšie zmetky, že
I inform you because we had some complications yesterday that on the machines that you have in your hands or devices, English is on station 1 and Slovak is on station 4.
just for your information, because yesterday were some confusions and I was confused also a little bit. So we can start.
Yesterday we covered quite a lot. And for those of you who came for the first time today, let me say welcome on behalf of the organizers, who are the Ministry of Culture of the Slovak Republic and the Intellectual Property Office of the Slovak Republic, together with the main partners, the European Commission, the EU IPO, and the Creative Europe Desk. This is the second day of the conference, Forming the Future of Intellectual Property. Yesterday we covered quite a lot, and this is one of the most important events of the year 2016 in the area of intellectual property. And in the evening you had the opportunity to enjoy a pleasant program at the Bratislava Castle. And the paparazzi of the Ministry of Culture have seen a few of you in the Salsa Club. I'm not sure that those who went to the Salsa Club are here today, but rumors are there that there was a lot of fun. However, all pictures will remain strictly private and confidential, and we will sell them as soon as we have them. So let us go to the next panel, and that's the European patent system and its future. We will cover that in the minutes to come, and the panel discussion will be led by Tomáš Klinka, Director of the Legal Department of and International Relations Department of the Intellectual Property Office.
Ladies and gentlemen, it is my great honor and pleasure to be with all of you and to moderate panel 4 entitled European Patent System and its Future. My name is Tomáš Klinka, as the conference moderator has just mentioned, and I've been working for the Industrial Property Office of the Slovak Republic for almost 19 years. Allow me to provide you with a brief outline of the panel and its structure. When you take a look to the program, you can see two main topics on the table and to be addressed by this panel. These are firstly unitary patent protection, hand in hand with Unified Patent Court, and secondly, Patent Cooperation Treaty in Europe. You might know that the newest international authority according to Patent Cooperation Treaty in Europe is Visegrad Patent Institute. On one hand, I realize that it's not going to be easy to draw your attention to patents in Europe when the things are happening in the US. On the other hand, the composition of this panel gives us assurance and high expectations of interesting discussion. We have 5 panelists. It is the biggest panel at this conference, and all of them are true leaders and exceptional speakers. To our pleasure, the invitation has accepted Mr. Mihály Zoltán Ficsor from Hungary. Mihály is IP Director at Gideon Richter, the biggest Hungarian pharmaceutical company. Before moving to private sector, for the last 15 years he had been Vice President of the Hungarian Intellectual Property Office. In this capacity, he represented Hungary in various international fora, including the Select Committee of the Administrative Council of the European Patent Organization and the Preparatory Committee of the Unified Patent Court. Mihály was also a chairperson of the Committee on Patent Law within European Patent Organization and led the Working Party of the Visegrad countries preparing the establishment of the Visegrad Patent Institute. In his keynote speech, Mihai will be dealing with our both main topics, unitary patent and unified patent court, and the PCT system in Europe. The second speaker will be Ms. Margot Fröhlinger, Principal Director for the Unitary Patent, European and International Legal Affairs at the European Patent Office. Before joining the EPO in 2012, she was Director at the European Commission in charge of intellectual property. This year, Margot was inducted to the prestigious IP Hall of Fame, and thus no further introduction is necessary. Margot will speak about the role of the European Patent Office concerning the unitary patent protection. Then we have Mr. Joachim Feldges from Germany. Joachim is patent litigation partner at Allen & Overy law firm and co-heads the German IP group from the Munich office. He has practiced complex patent litigation, both infringement and validity cases, for nearly 30 years and across all the technical fields. Joachim will share with us his rich experiences in patent litigation in Germany, with some interconnections with the rules which would be applied before Unified Patent Court. Joachim will be followed by Mr. Alexander Ramsay from Sweden. Alexander is the chairman of the preparatory committee, the Unified Patent Court, and the judge of the Swedish Patent and Market Court. In his former service as deputy director at the Swedish Ministry of Justice, he had been involved in the negotiations on the unitary patent protection and the Unified Patent Court. Alex will tell us where we are with establishing Unified Patent Court and what could be foreseen in the future. And the last panelist on my list is Mr. Alfred Radauer. Alfred is a senior consultant at Technopolis Group, Austria, a leading European consultancy for innovation and research policy. He is an economist and an expert in IP management, providing advisory services for clients across Europe, like World Intellectual Property Organization, European Commission, European Parliament, and European Patent Office, to name just a few. And now, ladies and gentlemen, it's time to invite our keynote speaker, Mr. Mihai Zoltán-Ficsor. Please take the floor.
Thank you, Thomas. To begin with, I would like to thank the organizers for having invited me to speak at this excellent conference, and my special thanks go to my Slovak friends for their outstanding hospitality. Future must be the most fascinating topic. This is the conclusion I have drawn from many years of experience with EU presidency conferences on IP. As far as my memory goes back, almost all of these conferences focused on future trends in IP, and even their titles usually implied that there would be a great deal of crystal ball reading at the event. This may show a number of things. It may indicate a constant, unrelenting concern about the fate and prospects of IP, but a lot of optimism as well. It may also reflect the need and desire to keep on improving the IP system, to adapt it to economic, social, and technological changes. Now, leaving these philosophical aspects aside, let me address the topic of this panel, namely the European patent system and its future. If you look at the brochure of the conference, you will find that one of the basic theses is that the European patent system is on the verge of the most significant change since the conclusion of the European Patent Convention in 1973. What this thesis refers to is, of course, the imminent advent of unitary protection and the Unified Patent Court. Although there might be some other trends or projects affecting the future of Europe's patent system, there can be no doubt that it is the UPP and the UPC that will have by far the biggest impact. In view of the high professional level of this conference, there is certainly no need to recall in detail all the elements of the unitary patent package. I'm sure you all know that the EU law pillar is constituted by two regulations adopted in December 2012 under the special terms of the in-house cooperation. Namely, they are the UPP regulation, which defines the main contours of unitary patent protection, and the translation regulation, which lays down the mainly transitional translation arrangements for unitary patents. And I'm sure all of you are aware that the intergovernmental pillar is constituted by the agreement on a unified patent court, which was signed in February 2013 and later on supplemented by two protocols on provisional application and privileges and immunities. It is an international agreement between the member states of the European Union to be ratified by them in accordance with their constitutional requirements. These legal instruments are treated as inseparable elements of a consistent single package. Therefore, the application of the two EU regulations is linked to the entry into force of the UPC agreement, and for the latter, 13 ratifications are needed, including France, Germany, and the United Kingdom. This package is intended to address and overcome the actual or alleged deficiencies and drawbacks of the current European patent system, such as fragmentation and complexity, high costs and the resulting lack of affordability, divergent judgments, and the ensuing legal uncertainty. Moreover, this package is also supposed to meet the needs of the European Union's internal market and facilitate its proper functioning, as well as to enhance the competitiveness of Europe's industry. From the viewpoint of the future of the European patent system, the single most important question is, of course, whether or not the UPP-UPC package can indeed meet the expectations of users and deliver on the promise of a simpler, less expensive patent system, providing best-in-class quality and legal certainty characterized by predictable and consistent multi-territorial judgments. If one looks at the current package from the perspective of the original ambitions, one might, perhaps a bit hastily, arrive at the conclusion that the system established by the EU regulations and the UPC agreement is somewhat suboptimal. Suboptimal in the sense that it falls short of fully meeting the original expectations, and suboptimal in the sense that it does not live up to the ideal of a perfect and flawless EU patent system. This is due to a number of characteristics of the package, such as the lack of EU-wide territorial coverage, a very peculiar non-EU law-based way of defining unitary protection, or the fact that the UPC will neither be a specialized EU court, nor will its membership and jurisdiction cover all EPC contracting states. In addition, in terms of simplification and cost effectiveness, the envisaged system may not live up to all the original or initial expectations. Well, although the UPP-UPC system may not entirely fulfill the original dreams about an EU patent system, it does have an undeniable major advantage over any previous ground designs of the past. Notably, that at long last, it has been agreed upon, and in all likelihood, it will start operating sooner or later, preferably sooner than later. There is no denying that it is the result and takes the form of a compromise, a thorough and multifaceted compromise. But at the end of the day, there is nothing wrong with compromises, as long as they prove workable and useful. Just think of the EPC and the EPO. In the 1970s, they were regarded as compromises, and today you can see what those compromises have resulted in. The EPC has 38 contracting states and 5 more extension and validation states. The EPO receives approximately 160,000 applications and grants more than 68,000 patents per year. It has become a global player in terms of its share of PCT work and its well-established cooperation with other major patent offices. This lesson certainly teaches us not to underestimate compromises, and it can fuel our optimism about the future success of the UPP system. In that regard, users' approach has also shifted from maximalism to realism. Back in 2001, the predecessor of Business Europe insisted that it would be better to have no community patent rather than a bad one. I assume Business Europe would today rephrase this statement to the effect that a suboptimal, compromised version of unitary patent protection is still much better than having none and continuing to dream about a perfect one. But one can confirm this by visiting their website, where they call for the swift implementation of the UPC package, UPP-UPC package. I am not a fortune teller. I cannot, of course, predict what the future holds for Europe's patent system. What I can try and do is give you a non-exhaustive list of issues, trends, and factors on which the further development of the system may depend, and maybe raise some questions about them. It is beyond any doubt that IP-based industries in general and patent-based industries in particular make a significant contribution to the European Union's economies. This has been testified by a recent joint study of the EPO and the EU IPO, the results of which have already been presented to you at this conference, both through speeches and in writing. Thus, patents seem to matter to Europe. On the other hand, the extent to which Europe matters to the patent world, i.e., to patenting activities at the global level, seems to be decreasing. Recent WIPO reports show that the geography of innovation and patenting continues to shift, and as a result, Asia has more than doubled its share of all PCT applications since 2005, and now accounts for 43% of the total, compared to slightly more than 27% coming from North America and 27% from Europe. The United States of America is the largest individual filing country, followed by Japan, China, Germany, and the Republic of Korea. Thus, Europe is obviously falling behind and needs to catch up with the most competitive and most innovative economies. In this regard, it is to be noted that while there have always been studies and cost-benefit analysis demonstrating the positive impact that unitary protection will have on applicants and patentees, in particular in terms of cost saving and simplified procedures, studies on the overall macroeconomic effects of the new system have been consistently lacking, at least at the European level. For instance, it remains to be seen what impact an increasing number of patent rights held by non-EU companies will have on Europe's competitiveness. It's worth noting that less than half of all European patent applications are filed by residents of EPC contracting states, and even less by those of the EU member states participating in the UPP enhanced cooperation. Therefore, lowering the cost of patenting in Europe will create an incentive not only for our companies, but also for overseas applicants. It's also doubtful whether we should really encourage an even more extensive use of the patent system. A rise in number of patent applications and patents is beneficial, where this is basically due to a growing number of inventions. What we really need is more inventions, not just more patents. There is ample evidence that too many patent rights, especially if they only protect improvements, incremental improvements or trivial solutions, can hinder competition and stifle innovation. Moreover, the quantitative pressure on the patent system has also given rise to concerns about its capability to maintain high-quality search and examination standards. It also remains to be seen to what extent the new European patent system will be capable of discouraging non-practicing entities or patent trolls. It is well known that SMEs are the backbone of the EU's economy. However, it is also well known and is proven by studies of the observatory that a significant majority of SMEs own no patents at all and might not even have heard of the patent system. Thus, our future largely depends on how we can help SMEs explore the full potential of patents and make a well-informed use of the patent system. To achieve this, we need to launch awareness initiatives that are better tailored to their specific needs, and we need to dismantle the barriers to their access to the patent system. We can only hope that the UPP-UPC system will be instrumental in meeting these goals, and that the specific measures envisaged in this respect will prove sufficient for making the new system SME-friendly. Another aspect of the future European patent system that may be worth considering is its territorial coverage. Some member states still seem to be delaying their decisions on becoming party to the new regime. This may be due to some impact studies dealing with the overall economic effect of the UPP-UPC package on their national economies, and/or this may be due to some financial concerns raised by the distribution key of UPP renewal fees as defined by the Select Committee. Question marks are surrounding the future role of national patent systems too. The relevant legal texts do include some reassuring language about coexistence and the important role national offices may continue to play. However, the long-term effect of the UPP-UPC package on national structures is quite uncertain. Some national offices already do not perform substantive examination of national patent applications and rely on the EPO even in that regard. Others may not be able to maintain their examining capacity and patent expertise due to the insufficient amount of incoming work. This may equally undermine the effective performance of some other patent-related activities, such as dissemination of patent information and advising potential applicants. It is also an open question to what extent the patent expertise of national courts can be sustained in the post-UPC era. This expertise will be needed as there will be aspects of patent law that will fall outside the scope of the UPC's jurisdiction, and also because the national courts will fully retain their jurisdiction over national patents. A few avenues seem to emerge in the various attempts to address the situation I have just described. One of them aims to reinvent national patents. You may recall that classical European patents cannot coexist with unitary patents, and parallel protection under these two titles is prohibited by the UPP regulation. However, this is not the case with respect to unitary and national patents. Thus, member states are, in principle, free to define in their national laws whether and on what terms the same invention may enjoy simultaneous protection by a unitary patent and a national patent. Where double patenting applies, specific provisions may be called for to address situations of parallel litigation and to protect defendants from being sued twice. In addition, irrespective of the possibility of double patenting, national patents may be of interest to those companies that wish to avoid the UPC's jurisdiction on a permanent basis. Another avenue open to national patent systems would lead to specific value-added services tailored to the needs of the local or regional industry. In most cases, this requires a pooling of resources and a targeted development of their competence. Good examples of such regional initiatives are the Nordic Patent Institute and the Visegrad Patent Institute. Both of them are international authorities under the PCT. They act for and serve the needs of specific regions in Europe. They both follow a model in which the intergovernmental structures are extremely lean and lightweight, and it's the participating national offices that perform the tasks of international search and examination on behalf of the organization. They are both intended to offer applicants a favorable option for entering the PCT system through the possibility of using local languages and with proximity to users, and to maintain and maybe further develop the patent-related expertise of the participating offices. A further option to consider would perhaps be some sort of rethinking and reshuffling the European patent network in an attempt to revitalize it and maybe reposition the national offices within it. Nevertheless, national patent institutions have to prepare themselves for further challenges. They are posed by, among other things, repeated calls from certain user groups for terminating national patent systems and providing for a single one-level patent system in Europe. The influence of such voices should by no means be underestimated. The digital world is another challenge, as with the expansion of e-business in general and electronic filing and prosecution of IP applications in particular, the need for local presence and for proximity to users may fade away. With a thinning or weakening patent expertise at national level, European institutions responsible for patent matters might have to face issues of democratic legitimacy, accountability, and efficient supervision. I'm fully aware that no presentation on the future of IP in Europe can be complete without addressing the issue of Brexit and its impact, but I will resist the temptation of dealing with this topic, as I understand that Margot and Alexander are more than ready and willing to elaborate on this topic, so I leave this pleasure to them. Let me conclude by referring to users' preparations that are going on. Indeed, they are busy preparing themselves for the advent of the UPP-UPC system. They have to review and evaluate their patent portfolios and take important strategic decisions on opting in or opting out their European patents. They have to revisit their co-ownership and licensing agreements from the viewpoint of the rules on applicable law and transitional provisions. They also need to redesign their patenting strategies in view of the new additional layers of protection, and in particular determine the factors they will take into account when they decide on requesting unitary effect for their European patents. The initial behavior of users will depend on a great number of different factors and considerations, and may vary from one sector of technology to another. All this will define the penetration rate of European patents with unitary effect and the take-up level of actions brought before the UPC. Thank you for your kind attention.
Thank you, Michael. Thank you for this very nice overview, and thank you particularly for underlying the importance of national offices as an integral part of European patent system, and also for mapping the challenges we are facing and all stakeholders are facing in this regard. In this moment, I would like to invite Mrs. Margot Völlinger for delivering her speech. Thank you.
Good morning, ladies and gentlemen. I'm very pleased and honored to have been invited to speak at this very important conference to such a distinguished audience in such a beautiful city with such fantastic weather, which makes me feel good despite of the disastrous news which we have to face this morning from the United States. But let's come to the topic of our panel. Our moderator is expecting me to focus on the role of the European Patent Office in the future unitary patent system. But let me make first some remarks about the question marks surrounding the future of the unitary patent system. And contrary to Mihaly, I cannot resist making some Brexit-related remarks. Now, as we all know, the unitary patent can come into operation only together with the Unified Patent Court. For the Unified Patent Court to enter into operation, we need 13 ratifications, including ratifications by Germany, France, and the United Kingdom. We have already 11 ratifications. We have 3 more countries who have completed the procedure in their parliament, Italy, Slovenia, and Lithuania, the most recent one. And in Germany, the ratification process is on track and is expected to be completed before the end of the year or early next year. So the outstanding ratification on which everything depends now is the ratification by the United Kingdom. Currently, everybody is waiting for a reply from the United Kingdom about their intentions. And we all hope that the reply from the United Kingdom will be positive, of course. It goes without saying that not only the short-term ratification, but the long-term participation of the United Kingdom would be extremely beneficial for the future unitary patent and unified patent court system. The reasons are self-evident and obvious. I will not even touch on them, because maybe Alexander will say something more about this. So we all hope the United Kingdom will join the system. However, if the United Kingdom cannot join the system, then there are preparations in some of the other capitals to move ahead without a UK ratification. That would be a suboptimal option, only a second best option, but something is clear: there is strong political will in some of the other capitals to go ahead, to bring the system into force. This time round, after more than 50 years of negotiations, discussions, failed attempts, this time round, it's not possible to simply shelve the whole project again. And Alexander, I think, will say more about this. Now, I come then to the role of the European Patent Office in the unitary patent system. In order to understand the role of the European Patent Office, one has first to understand the concept of the European patent with unitary effect. Contrary to the European trademark and the community design, the European patent with unitary effect is not an autonomous EU title. It's a European patent granted by the European Patent Office under the rules and procedures of the European Patent Convention, to which only after grant unitary effect can be attached at the request of the patent holder. So until grant, nothing changes, neither for the applicant nor for the European Patent Office. After grant, the applicant has two different options. He can either go down the classical route of validating his European patent country by country, or he has a new option now, which is to request unitary patent protection from the European Patent Office. To understand this option, you have to look into how the system works today. Once the patent is granted, you have to validate your patent country per country. You have, in many countries, you have to provide for translations. You have to get these publications of these translations. You have to pay fees. It's all very complicated, and most of the time, you cannot deal with this yourself. You have to pay patent attorneys or specialized service providers to deal with all the formal requirements and the procedure. And this complexity and the costs implied hamper very seriously patent access to the patent system for SMEs. In the future, you have only one validation procedure. You have to deal only with the European Patent Office and not with a multitude of different national procedures. In addition, the procedure before the European Patent Office will be very simple and very straightforward. There are only very few, very simple conditions. In order to request unitary effect, there will be online forms available from the European Patent Office, very simple to access, very simple to fill in. We have run a test with users, and all the users have confirmed the user-friendliness of the new procedure and of our forms. The good news is also that the procedure at the European Patent Office for requesting unitary effect will be totally free of charge. So instead of, as the situation is today, paying fees for validations for a number of national offices, you will in the future have a procedure which is absolutely free of charge. But in addition, you can make even money with the procedure. Because currently, if you are an SME, you have the possibility to file a patent application not only in one of the working languages of the European Patent Office, English, German, or French. You can file an application in your national language, then you have to translate the application during the procedure, and this involves a cost. Already during the pre-grant procedure, you can get a fee reduction if you are an SME to compensate for these translation costs, which amounts around about to 500 euros. So this is the first step of compensation for the translation costs. If after grant you file an application for unitary effect, you get, together with the registration of the unitary effect, you get another 500 euros back paid by the European Patent Office to you in cash, together with the registration of unitary effect. So contrary to validations at national level, where you have to pay, at the European Patent Office, you get money back. In addition, the fee level is very attractive. The fee level is, corresponds to the accumulated fees for 4 countries, and for the first 10 years you have to pay only 5,000 euros in terms of fees. 5,000 euros over 10 years, that is not really too much. Let me say briefly some remarks, and even if I'm running out of time, but I have to react to some of the remarks from Mihaly. Because Mihaly has said that maybe the unitary patent has some beauty spots and is a compromise which is not very nice. Well, of course it has some beauty spots, but there is the entire European user community behind this system. In the running up to the Competitiveness Council in September, all the major European user associations, including user associations representing small and medium-sized companies all over Europe, have urged ministers to bring this system into force as quickly as possible. Second, Mihaly has said, well, maybe this will lead to an avalanche of patents, and we do not need more patents, we need more inventions. According to all studies we have carried out, this will not lead to more patents. It will lead to a broader geographical coverage, to a better functioning of the internal market, for better value for money, and for an improved access to the patent system for SMEs. And finally, Mihaly has said, well, this all creates problems for national structures, for national offices, and for national courts. We do not think so. As concerns national offices, we are ready to expand our cooperation with national offices and to help them, to support them in developing new and innovative support strategies for their companies. And as concerns national courts, there is a unique chance for national courts because national judges can participate as part-time judges in the UPC. They can then benefit from intensive training for UPC judges. They can gain experience, and they can feed back this experience and this training into their activity as a national judge. So, to conclude, we think that the unitary patent and unified patent court system will become a real success story, and it will be a success not only for the users, it will also lead to a peaceful and fruitful coexistence between national and European structures, and thank you very much for your attention.
Thank you, Margaret, and thank you for your in-depth remarks on UBP. And now it's time for a switch to litigation, and this is the role of Mr. Joachim Feldges. Joachim, please come and deliver your speech.
Good morning, ladies and gentlemen. I'm very honored and pleased to participate in this very distinguished conference, and I do that as a patent litigator. I will not litigate this morning, don't be afraid. But what I want to go through with you is through 6 points I have picked up based on my experience in German litigation in particular, and then look on the UPC for these points. And these are competence, this is bifurcation, this is a question of front-loaded proceedings focused on written submissions, costs, time, and finally, language. Let me start with competence. Competence generates trust, and trust is a requirement for the choice of venue. When we advise our clients where to file an action, we need to have trust in the competence of the courts. And if we got it wrong, we will be grilled. And let me say, in my 30 years, I have been grilled several times, and I don't want to go through it again. Germany has about, probably counts for more than 50% of all patent litigation in Europe. Probably 1,700 to 2,000 cases. There are not real statistics about it, but if you count together the major courts, you come to that figure. Most of these cases concern SMEs, yeah? You have, of course, the famous big cases, which are reported in the press, but most cases concern SMEs. So there's experience, broad experience with SMEs in these courts. There are famous courts in Düsseldorf, Mannheim, Munich, and Hamburg, and we have, I'll come to that, the bifurcated system with the Federal Patent Court for validity. Competence is based on 2 things, experience and specialization. And specialization means that you should allow your judges to specialize, yeah, in that field. That is a requirement for building competence. And that has been done wrongly in some places in Germany in the past. I think it has been done better now for a long time. And we have judges who spend, I wouldn't say their entire life, but all the cases they decide are patent cases. Of course, it has to do with the number they have to deal with. Competence is, and that's the next point, an ongoing process. That means there is no point in getting self-complacent because you have competence. That's the point when you lose competence, when you get to that point. Yeah? You still can learn from others, and you can also learn from judges in other countries having fewer cases. There is no reason not to believe that. Now, looking on the UPC, I'm very happy that we have about more than 800 applications, and among those, although names are not published, are those of most experienced and talented candidates, both with legal background and with technical background. What does it tell us? You will probably see the most experienced judges in Europe in the UPC. And that means there is reason for having trust in the competence of these judges. That doesn't mean that you will have to face the quotation mark leftovers in national courts, in particular as most of the judges will work part-time in the beginning, so that means both in the UPC and in the national courts. But the trend is clearly to the UPC. So that is a big point for competence. As regards those judges coming from the countries where there are fewer cases, first of all, they are most welcome to build together a European patent law. This is not about exporting German patent law to Europe. This is about building a true European patent law. And they will be integrated, they are already integrated through training, through education into the panels, into the practice, to see how this is handled in other jurisdictions, and the same should happen with the judges in Germany, seeing what their colleagues in the other countries do. And actually, what pushed the process the most was that judges started to meet in San Severo and exchange experience. That's the beginning of building a European patent law, that you talk to each other and exchange. So a strong basis for having trust. Now, bifurcation. Despite the fact that I'm a German patent litigator, I'm not a fan of it. Germany has goods which we can export. Bifurcation is not among them. And there has been a lot of reluctance, for good reasons, to build it in the UPC rules. I think it's a very, let us say, small version of bifurcation which ended up there. Why? We have an enormous problem of a time window between decisions on infringement and validity. And that means that if you are held liable for patent infringement, because you cannot avoid patent infringement with broad claims sometimes, but the patent is invalid, you are dead. And resurrection happens in the Bible, but not in the patent field. That means you come too late with the patent being declared invalid than after 1 year or later. And that's a good reason why bifurcation should remain the exception in the UPC. And I hear with some satisfaction, and I have trust in my well-esteemed German judges, that they will probably handle it with great reluctance in the UPC, for the very obvious reason to keep control on the entire litigation and dispute and not export the important question of validity to a central division where they can handle it themselves. It is also that the competence of the panel to decide on the validity is there. There is the possibility to join a technical judge, and let me be honest, I don't see even in these cases where in the existing German system, the judges decide on the validity of utility model rights, that they get it worse than the judges in the Federal Patent Court. So bifurcation is there, but it should remain an exception, and there may be some cases where this is justified, but there is no reason to fear that bifurcation will be the rule in the UPC system. Third point, front-loaded proceedings focused on written submissions. That is very much the German system, not only the German system, but in particular the German system. You need to come up with all your arguments and evidence at an early stage, And that has certain pros, definitely. Yeah? There is no room for tactics and surprises, and the judges see very early and can prepare themselves to all the arguments. That is the good side of it. But there's also a downside, and the downside is on the oral hearing. I won't go that far, and it was fortunately not a German judge, but a Swiss judge who once said that oral hearings are a waste of time. And actually, if as a counsel you prepare for an oral hearing and you feel like in a theater, you try to plead in the best way, but in the end you feel from the outset that it is a waste of time because the decision has already been taken. That is not really satisfactory. And this is also not what it should be, because it is the exchange, the discussion of legal arguments which contributes to the quality. It is really and should be the interest also of judges to listen to arguments, not to repeated arguments which have been already submitted in writing, but to be open to the discussion. And that's why I think in the UPC we should be careful that the oral hearing doesn't lose its importance, in particular when, unfortunately, we won't have our UK judges having that broad experience in oral hearings among us. Costs. Costs are essential, of course. In most cases, costs in Germany are okay because the value in dispute determines the cost, and the value in dispute is quite limited for most cases. But we have a problem with the major cases where the value in dispute is increased substantially upon the initiative of some courts, and that pushes the costs to the sky. And that is not affordable and may even be a problem of access to justice. And court fees are an important element within the UPC for good reason, to self-finance it, but it should be handled with some caution in view of these experience. Time. Time is a part of efficiency. Obviously, the time in the German patent litigation differs between 6 months or 8 months in the Mannheim court up to the trial to maybe 12 in the Düsseldorf court, which is still efficient. And then you still have the PIs, the preliminary injunctions available, and some courts are more inclined to grant them, and Hamburg court is a good example of that. The time plan for the UPC is very ambitious, with a 1 year. Well, in the end, quality has a priority, but nevertheless, I think it is right that there will be some discipline about the timing of the proceedings, and which also means that you have to work very efficiently also from the council's perspective, but also from a party's perspective. And that brings me to the last point, language. Language was the killing factor for 50 years of a UPC, because with all the political reasons to have all the languages in, it was not affordable. We have in Germany, in the classical litigation, some courts accepting English documents, for example, Hamburg, it's a port city, yeah? And others being very reluctant, in particular Düsseldorf. Yeah? These judges sometimes know very well English when they speak on conferences, but if you submit something in English in the proceedings, it gets away for some miracle reason. Anyhow, with the UPC, after a long fight, we have now a solution, at least for the local divisions in Germany, with packages. It's up to the court whether they accept documents in English or whether they accept even testimonies in the oral hearings in English, and still may deliver their judgment in German. And that will be a decisive factor for the choice of venue, because if you lose time with translations in the ambitious time frame to translate for your Japanese, Korean, whatever clients, then you better go away where you can really use the time on the arguments and not on the translation. I finish with that before I get taken out here. Thank you very much for your attention.
Thank you, Achim, for this interesting mapping of litigation in Germany with connection with UPC. And now we can expect by Alexander Ramsay some first-hand information from preparatory committee of Unified Patent Court and maybe a little view behind the corner we can looking forward. Thanks. Alexander, please.
Thank you very much for the introduction, Thomas. Well, since Margaret has told you almost everything that I plan to say, so that enables me to start talking about ice hockey. You see, being a Swedish national visiting this country, you can't help thinking about all the very good Slovak ice hockey players. Players like Miroslav Satan, Marian Gaborik, the Hossa brothers, which I've been enjoying seeing play during the past years. The games that my team is playing against the Slovak team is always great ones, I would say. During the last occasion, the World Cup of Hockey, which was played in September, your players actually gave our players a proper beating, and you also gave several of the other best teams in the world a proper beating. And you actually advanced to the finals. However, you did so taking part in a joint European team where your players pooled together with players from many other different countries from this great continent. In my opinion, this is a good example of how strong we are when we stand together and pool resources. And in my opinion, this goes also for the UPC. So this brings me to the main topic of my intervention. I believe that the UPC shows Europe's actually at its best. We have been pooling resources, bringing in the available expertise, and being able to merge the best of our different national legal orders into something brand new that has never been done before. A unified court dealing with civil law actions. As you know, I'm the chairman of the preparatory committee. The committee was 3.5 years ago given the mandate to prepare the establishment of the new court. And I'm proud to say that at the Competitiveness Council in September, I had a great pleasure to report to our political leaders that the committee has indeed fulfilled the mandate given to it. Meaning that the preparatory work is completed to a level where it's possible for us to move into the next phase of the project, which actually would mean that we're ready to launch the actual organization, the Unified Patent Court. During the past year, I would say that the committee has handled an extreme workload and concluded a lot of different issues. We have been able to agree on the rules of procedure, including the court fees. We have completed more or less the IT system of the court. We have agreed on the recruitment process. We have actually started recruiting the judges, as you heard. We have agreed on staff and service regulations for the judges and for the staff of the UPC, including issues like healthcare, social security, pensions. We have spent a substantial amount of effort on organizing the corporate functions of the new organization, which is something that you easily can forget when you view this from the outside, that this is actually a real organization that is supposed to function in real terms. And we have also seen actual court buildings popping up all over Europe, which is a very tangible sign of that this is actually happening now. Now, this wouldn't have been possible without the very hard work and dedicated efforts of all the national experts taking part in the different working groups of the committee. And I'm very proud to have been the chair of this group. So, the preparatory work is more or less concluded. What about ratifications? You have heard from others that we have 11 ratifications as of today, but we have also several countries which are more or less concluded on the national procedures. And at the last meeting of the committee in October, I counted up to 5 member states being very close to conclude on the national procedures and then being able to ratify. And then I wasn't counting Germany and the UK. So it's safe to say that when the UPC will open shop, it will be a lot more member states taking part than the 13 member states which is required formally. This, I believe, is very encouraging. Now, as you know, we shall need Germany and the UK, and what about the Brexit? As you know, as it stands, we need to have the UK ratification in order for us to be able to allow the agreement to enter into force. This is how the agreement is worded currently. The UK is still an EU member state. It's still a signatory state to the UPC agreement. So it's perfectly possible for the UK to ratify. In addition, during the last month, we have also seen that several experts have come up with the conclusion that it's also perfectly possible for the UK to remain in the UPC, even though it would withdraw from the UK, from the European Union. Now, the ball is in the UK's corner, I would say, because the question is whether it's politically possible, I would say, for the UK to ratify. At the Competitiveness Council in September, the responsible UK minister made it very clear to the other delegations that she takes this issue very seriously and that she aims at coming back to the other member states as soon as possible with a message on the UK position in this, what the UK will do, and that the UK has no intention to stand in the way of a swift entry into force of the system. So, but what if that wouldn't materialize then? What will happen then? Will we have a substantial delay? Like Margot said, I would say that there is a substantial will in the other member states to move ahead regardless of whether the UK ratifies or not. From my perspective as the chair of the committee, I think it's of paramount importance that we don't get a pause in the project. As you heard me saying, the UPC is no longer a mere paper product. It's an actual structure with a lot of engagement outside with different contractors, vendors, processes which are being run, which actually costs money. A lot of investments being done in the different member states in facilities, court buildings, IT systems. So I think it's of paramount importance for the project that this isn't being paused. And in addition, as Margot told you, I think it's of paramount importance to the European users. In the run-up to the Competitiveness Council in September, the delegations received a lot of letters from basically all the different European user organizations and also from major European companies, urging the political leaders to find a swift solution to enable the system to enter into force without any delay, and hopefully also to enable the long-term participation of the UK. So I would say that there is a substantial political will to find a solution to this without this being delayed more than necessary. So I'm convinced, after knowing all the different difficulties this project has survived during the years, we have found solutions to the language issue. We have survived one opinion and 2 litigation processes in the ECJ. We have launched enhanced cooperation for the 2nd time only in the history of the European Union. So I'm also sure that we will find a solution to the situation we are in right now. Thank you for your attention.
Ladies and gentlemen, we have 20 minutes to the end of our panel. So ahead of us is the final panelist, Mr. Alfred Radauer, who will talk about small and medium enterprises regarding patenting. So please, Alfred, come here and start your speech.
Okay, so first of all, let me thank the IP office from Slovakia for the kind invitation to be here, a country I have come to love very much, as I have now family ties to this country and I'm often here. So it's a pleasure to be also here professionally. As discussed, I'm going to talk about SMEs. This has been a topic that has come up already in past presentations, also here at the panel. And when I had to think about what I should talk, when I should talk about SMEs, I thought I'd take today a little bit more of a provocative view, yeah, something like a devil's advocate, yeah, challenging some common views, yeah, not necessarily because I believe all these common views, so that's of course always the danger of being the devil's advocate, that we are mistaken for the devil, but to give a little bit food for thought whether all the assumptions we are having are really the correct ones and whether we are really progressing in the right direction. With, of course, the possibility that we come to the conclusion that many things are wrong. So I hope that there will be a discussion, even if the time is limited for this panel, maybe in the breaks also between among you. So where do we stay? Yeah. I won't go very much into the detail of the state of the art, but as this has been already discussed very much, and also at the beginning of this panel in the keynote speech, yeah, we know that patents have a number of benefits. We know that the possible benefits of patents have broadened, have increased over time. Yeah, before it was just protection for a product you produced, you invented. Now it can be used for a variety of things. And there is, of course, the issue then, if you have so many advantages of using a patent, why don't SMEs use more patents? And these are the common disadvantages in the lower part of the slide that are cited. It's costly, SMEs don't know the way around, you have high costs related to, and risks related to enforcement, it takes long to get a patent granted. So there's lots of reasons that have been put forward, and the basic assumption is now if we alleviate all these barriers, SMEs will start to patent and the world will be a better place. Yeah? And it's questionable, if you go a certain line of reasoning, whether this will truly be the case, not necessarily because these kind of cost-benefit considerations have to be done also by large companies, so there is always an issue whether you would file for a patent or not, but also whether some of the assumptions regarding SMEs are true. So here is the 4 things that I will argue as a devil's advocate. First thing, there is no SME. Yeah? There is no such thing as an SME. Second thing, SMEs may not be too much into patenting, we have heard so, but that might be not necessarily a bad thing. Yeah? It could be actually good. Yeah? Thirdly, and that's something that's often forgotten in the policy discussion on patents, is that you always talk in policy when you talk about SMEs from a right holder's perspective. So you have the SME that has an invention and it can't really patent and enforce its right. Yeah? In fact, what's often forgotten is that SMEs often find themselves on the other side of the litigation table as defendant, having infringed one other's patent. Yeah? And in fact, now we are doing the evaluation of the IPR Enforcement Directive on behalf of the European Commission. We're making an evaluation report on that, and we have come already to some statements that say that this type of case where the SME is defendant and the large firm is attacking is much more common than the other way around. Yeah? And then there is, of course, the issue, once you understand how SMEs work and what the issues are, how to reach out to them, what type of support to give, and when to give it, which also relates to lawmaking, fee structures, and so on. Yeah? And the devil advocate's hypothesis is that the unitary patent could lift the challenges for SMEs to a new level. Now, it would be a different level. The question is whether it's a more challenging level or even a better level, but let's see some of the arguments that have been put forward. And again, because we are doing the IPR Enforcement Directive, this is again a disclaimer, I won't want to be seen as having conclusions already there. So I want to be kind of having the liberty to come to completely different conclusions than here in my slides, so it's just for discussion. So, the non-existing SME, why does the SME not exist? I mean, of course it exists, but it's a very, very heterogeneous population. Yeah? And in our study practice, consulting practice, there are certain things, particularly in relation to IP, that need to be considered. First of all is the industry the SME is working in. Yeah? Certain industries are more patent active, patenting system works there reasonably well, like in pharma, for example, patents are a currency, a common thing. Certain industries do not use patents at all. Other industries use patents in a different way. So you have to make here a clear distinction on, the industry structure and the way patents are used there. Then what we find is also you need to be a little bit more specific in terms of your size considerations. Yeah? We found, for example, that a typically critical size class, and it's always plus minus something, is SMEs with less than 10 employees because they have real resource problems, real issues in terms of available money and so on. And we have also another class of non-SMEs that have problems similar to SMEs because they just fall outside the scope of the EU definition of SMEs, which is companies with 500, 1,000, 300 or 400 employees. Yeah? And this is not a class of companies that's highly discussed, but it's, for example, very prevalent in Germany in terms of the German Mittelstand. Yeah? There's also a difference on whether SMEs are venture capital backed or not, because if you have a large venture capitalist fund or several funds behind you, it's much easier to go about patenting and enforce things than if you're completely on your own. Yeah? There is a difference of geography. Speaking of Slovakia, being a Slovak SME or being a German SME in certain industries does make a difference in terms of available resources and ways of doing things. Yeah? There is a difference according to available patent expertise in-house, which we found in many studies to have very subtle and important implications, as in many instances SMEs, for good and sometimes for bad reasons, outsource completely their patent handling to an external patent attorney. So they actually know very little themselves about patenting matters, and you would have to talk to the patent attorney, which takes very specific views, and sometimes that's not good. Yeah? And then there is difference according to business model, and I'll come back to that because I think there is a subtlety here, particularly in the context of SMEs, that could also explain, which needs to be then solidified with further research, why SMEs may not make larger use of patents, even if the unitary patent would work in a perfect way and enforcement would work in their favor. So let's get to some study results, and the EU IP office has been mentioned. This is another study that was done on community innovation survey data, actually quite older ones, but it's interesting because it's done on innovative SMEs in Germany, knowing of course that German SMEs are actually innovative and in very patent-friendly industries, I would believe. And even in these patent-friendly industries, you will find that the patents are only used to some extent of 15.1% by these SMEs, and you find a much higher reliance on informal protection mechanisms like keeping things secret, relying on the complexity on design, lead time advantage. Now this is a very known figure. What this study makes it particularly interesting is that it analyzed how these SMEs combine the different protection instruments. And they did a cluster analysis, and they found out that you have an informal protection group which consciously uses trade secrets, lead time advantages, which is 19% of the company base. Remember, innovative companies, so companies that introduce new or significantly improved products. We have a patent-oriented group which uses patents, but also uses trade secrets and lead time advantage very much in combination. But this group is only 11% of the company base. We have a copyright-oriented group which uses copyrights very much, which is only 6% of the company base. That's very much to do with creative industries, and also these figures have to be seen in terms of the selection bias of the study authors, where they focused on certain industries where copyright is not so important. But we also have the non-protection group, which do not do anything, and this is 2/3 of the SMEs. Yeah? Now this picture will likely differ across countries, depending on industry structure across time, but we have qualitative feedback from a lot of attorneys and studies which we did that more or less this figure holds true. The question is that a good distribution? Do we want to drag all these people from the informal protection group to the patent-oriented group, or from the non-protections group to the patent-oriented group? And given the obstacles SMEs face, I just quote now as a kind of a reference, a patent attorney which is retired and which has been in industry, who said, if I were an SME, I would only patent in 2 cases, namely if I had really a great invention, really great, yeah, or if my competition starts patenting, because at some time your competition will drive you out of the market. So that's when I would use patenting, and otherwise I would rely on other protection mechanisms, because it costs less, you wouldn't disclose your information, you can always stay in the lead, and so on. Yeah. Let's do a case study, and I am glad that Mr. Joachim brought over the case of the bifurcation system in Germany, because coincidentally I have an example from Germany, which is a type of SME which we have encountered, so the profile is quite similar, and it's worth talking about it. Yeah? So we have an SME at the size of about 240, 250, 300 employees, so a borderline case whether it's still an SME or not. It's active in an industrial technology, something that the company itself would consider as a typical German Mittelstand, which practices actually production. So it's using patents basically to protect its own produced things. It's positive about patenting, and it tries to patent its good inventions. So it doesn't try to patent everything, but good inventions, which leads to a certain number of few patents per year that are filed by this company. Now, this company has never had found the need to enforce its good patents, but it has found itself to be quite frequently at the opposing table, being attacked by industrial large firms who say that the company infringed their patent. Yeah? And it went to litigation. It didn't went to mediation and arbitration, it went out to litigation to the very end. And the procedure has been always the same. Namely, first, the company was found to have infringed the patent. Yeah? Sometimes there were even preliminary measures in place. And then many, many, many years later, it was found that the patent should not have been granted at all. So it was invalid. Yeah? So this infringed but invalid case. Yeah? And as Joachim said, there is no resurrection from the dead, yeah? For a time span of 6-7 years where you cannot do business, where business partners won't do deals with you because there is some legal uncertainty, you have a great loss. And even if you win in the end, you actually lost, yeah? So this is, of course, the situation, and it has increased, of course, the awareness of these types of SMEs on IP very much, yeah? And the consequences that the SME has been done have been quite interesting, yeah? They say the true problem lies in the quality of patents, yeah? There are so many patents that you can invalidate that the bifurcation system can be abused to basically use weak patents to be enforced, yeah? And so one of the immediate conclusions would be we do not need as SME cheaper patents, we need more expensive patents that are thoroughly examined. Because for an SME of a certain size with only flagship patents being patented, the costs for application, validation and maintenance seen as a percentage of turnover is not so high as the costs for always being in litigation, for always finding defensive action and going to validity. Yeah? And then there is this issue of the specific business model. Yeah? We ask these SMEs, I mean, you could enforce your patents maybe. You could try to go for lower quality patents and try to use them against industry. And here the thing is, they say we have very specific business models, we focus on certain things, and we feel if we do go more into the patenting game and enforce lower quality patents like the large companies do, first of all, our chances of success are not so high. Yeah? Secondly, it will be still risky. But thirdly, we don't want to. We are not in that business. We want to produce our things. We want to have freedom to operate. Yeah? So even if the things would be improved, the company would probably not file for more patents because it would only file for the inventions that it truly considers radical. Yeah? Now, if you go to the UPC, and I took a quote from a commission paper, then you find that the costs for litigation would probably be very high. Yeah? So the question is whether this is actually SME friendly, coupled also with the uncertainty over litigation outcome. I mean, one of the things about this cost arrangement for the UPC is that you would basically avoid or fight this problem of patent trolls of non-practicing entities. It's less attractive for non-practicing entities. But then we have also examples of SMEs that sold the patents to other entities to enforce them, and which then basically cannot use a usual enforcement procedure that they have had anymore. Yeah? There is a proposed solution in terms of a patent litigation insurance that the Commission is very much advocating. However, as of now, good evidence whether this can work is really hard to get by. Yeah? And particularly important for the issue of Slovakia, we have the issue that because European patents at the moment, the bundle patents are not validated or litigated, as we've also heard yesterday for Slovakia, in certain Eastern European countries very much. Now all of a sudden a whole class of SMEs will become fully confronted with valid patents in Europe and need to be made fit for that purpose. Yeah? So I won't go into that too much, but just to say there is more to the cost side when SMEs are to be supported. That also has to be taken into account. But the broad conclusions coming from this type of argumentation is there needs to be a high awareness for the double side of the coin nature, which we find very often in IP. Yeah? So things that could be seen as positive from one viewing angle, taking a slightly different viewing angle turn out to be negative. So the issue, and that's very challenging, and I don't envy the lawmakers who are there, they are absolutely splendid dealing in that problem, is to always find the right balance and get these different views right. Yeah? Another conclusion I would draw is no direct driving of numbers of patent filings by SMEs should be seen as a success measure. Yeah? Unless, and that's again a problem, issue if you look at China, if you want to use thickets of patents as a weapon in the industrial policy to lower the freedom to operate of companies in other countries. But that's again a balance issue. Yeah? Quite something that I would support immediately is that if you have support for SMEs, you need differentiated approaches. Yeah? You need really to be as much one-to-one and specific to the SME as possible. Yeah? And in terms of lawmaking, there are probably some things that might look special or small, but which could make a huge difference. Yeah? And in the course of the evaluation of IPRED, I put a question mark because we are working on it and we are trying to interview many people. But in the course of the unitary patent, one thing is of course that because of the unitary patent being a new instrument built on top of existing instrument, the layer of complexity increases, which means more strategic options, but which also means probably also more things to get wrong by an SME, which underlines continuous training and awareness raising as an important topic for SMEs overall. And then the one thing, one needs to have the quality of patents to be discussed, to find the right level of quality so it's not dissuasive but actually persuasive of innovation. Yeah? So thank you very much, and I hope this gives some food for discussion.
Thank you, Alfred, and I would like to say one remark as a lawyer that it seems to me that the best devil advocate is economist, not lawyer. And now we have a couple of minutes for discussion. Maybe we can open discussion for you from the audience to respond by our panelists. So please be prepared and ask for the floor. In the second row, please.
Thank you. Susanna Hečko from Allen & Overy in Slovakia. Many countries in Eastern Europe, they are hesitating with ratification process, including my country, for economic reasons. But I have heard that there is a study which has been published by Slovenia, and apparently it says that the UPC is going to be good for Slovenia. I was trying to find that study, but I couldn't find it. So my question is actually to anybody who can answer my question, is that study publicly available? Can we have a look at it? Thank you.
First of all, maybe this is a question to our Slovenian colleagues. But if anyone wants to respond, please.
So my name is Helena Zalaznik. I'm from Slovenian Intellectual Property Office. And the answer is this study is published and is available. It is on our website as a notice. But unfortunately, it is only in Slovene language. Yeah, you can use maybe Google Translator, I don't know. This study is over 100 pages, but only in Slovene. Yeah, thank you.
Thank you so much, thank you. Another question is coming from which angle? If not, we can maybe offer our panelists to have a reaction of each other if they want. So, please, Mihai.
Thank you so much. I think the audience has noted some slight differences of view between Margot and myself. This is usually something that makes speeches like this more interesting, but I have to disappoint you, really. She might disagree with me, but I don't disagree with her. I mean, she referred to the fact that users are fully behind the package, and that's what I said. That's what I said when I pointed out that users moved from maximalism to realism. And I quoted their statement from their website. They are fully behind it. And I do applaud this, I mean, because that's a very constructive and realistic view. Now, the second point about national structures. I don't think that they are in danger, and I don't think that the package is bad for them. I didn't say that. What I said was that they should adapt themselves to the new situation. They have to find new ways of continuing to serve their industries. And this was what I really wanted to say. If it was not clear enough, that's my mistake. About the avalanche of patents. Well, there, perhaps, we might have a slight disagreement.
Not a slight.
Well, I mean, Margot referred to the fact that there are studies and polls that show that there will be no growth in the number of European patent applications due to the introduction of the UPP system. Well, to what extent these polls and studies are reliable? Well, just think of the result that we were informed just a few hours ago. I mean, there were polls that pointed in an entirely different direction. But also, maybe we didn't read the same studies, because I did read some studies that pointed out that there will be a slight increase in demand for European patents because the UPC system will make it more attractive. And this is a real expectation. But this is not the real issue. Because I was not speaking about what the situation would be. I was not talking about sein. I was talking about what it should be, about sollen. So what I said was that the question is whether we should encourage applicants to file even more applications, whether this should be regarded as an achievement or a major objective that we should have a higher number of applications and higher number of patents. Well, this is an issue that, of course, can be discussed. Now, about these beauty spots. I think it's like the way you bring up a child. You have to accept and live with the fact that your child is not perfect. But you still do love him or her, you still care for him or her, you still look after your child. And you try and help him or her grow and overcome his or her weaknesses. I mean, this is the way I think we should approach our common baby called UPP and UPC. Thank you.
Thank you. Margot, you want to react, please?
Yes. I want to react only on one point. This is the increase in patent applications or the increase in validations. I really think that all studies which I have read, and we have read everything available, show that there will be no significant, there may be a very slight increase in patent applications, but there will be not a significant increase in patent applications, at least not in the near future. There will, however, be one difference. That is clear. There will be more patents valid in Slovakia, for instance, and in other member states, as is currently the case. Because currently patents are validated because of the costs and the complexity of the system. Patents are validated only in a very small number of member states. On average, out of the 25 member states who participate in the unitary patent, on average only in 4 countries. So, and there will be many more patents if the unitary patent really takes off. There will be many more patents which will be valid in Slovakia than is the case today. And that is sometimes seen as a problem and as a reason for concern, because it is said that companies then in Slovakia or other smaller countries will lose their freedom to operate and will be confronted with many more patents and will have to pay royalties or will not have the possibility to copy. Let's be frank about it. And we think really, and that is what all the economists think we are talking about, it's absolutely wrong to think that you can shield your companies against patents and that it is good to encourage them to copy. Because companies should not copy, they should make incremental inventions, they should be encouraged to be innovative and not just copy other people's inventions. And this is particularly true for a small country such as Slovakia, because you are a small economy. If your companies want to grow, want to invest, they have to export. One of your major export markets, for instance, is Germany. So all the patents which will be unitary patents, they will all otherwise have been validated in Germany. So you cannot export your products to Germany if they are validating, if they're infringing German patents. And therefore, it is wrong to think that it is good that few patents are valid in Slovakia. And this is also the study which has been presented at a very interesting conference in Slovenia, where I had the pleasure to attend. The study in Slovenia has also shown, for a small country like Slovenia, it's important that their companies are encouraged to innovate and to export. And that should be very much helped by the unitary patent.
Thank you, Margaret. And the last speaker, please, because we are a little bit run of time. So please make an agreement who will be there.
So sorry. So you wanted to say. Sorry. I just wanted to follow up to Michael's wonderful picture of bringing up a child. And we have carried out, already 2 surveys on corporates what they expect from the UPC, what is the confidence. The good news is the highest confidence is with UK companies in the UPC, which was just a few days before the Brexit vote. But what is more interesting is there is a development. In the beginning, there was a large tendency we will opt out and let others get their, let us say, wounds from being the pioneers in that court. And then we see a growing tendency to say, if you really want the UPC to be a good court, then please be part of the game. That's the best way to make it a good court. Because if you stay outside too long and then later on may be confronted with the UPC anyhow, then it has developed without your influence. And I think there is some truth in it, and also many corporates have taken at least this differentiated approach that they need to be part of a game in order to make it a good success. And I think that may be trivial, but it's true.
Thank you, Joachim, for these last words. And I would like to ask you, the audience, for the big applause for the panelists, please.
Thank you, ladies and gentlemen. Ďakujem aj vám, Tomáš, za túto odbornú diskusiu, že ste to...
And also thank to you, Thomas, for this discussion.
Maybe time for a big hug. I don't know. But in 15 minutes, we will continue. In 15 minutes, we will continue with copyright reform, exceptions and limitations. Dámy a páni, je tu teda čas pre kávičku. Skúste sa poponáhľať. O takých 15 minút by sme mohli pokračovať reformou autorského práva, limitmi, obmedzeniami, výnimkami. Dámy a páni, pokračujeme teda ďalej. Výnimky a obmedzenia.
Ladies and gentlemen, we will continue with the exceptions and limitations in the context of reform of intellectual property law. This is another field, and you surely know that various member states have various regulations, and this results in a number of hardships and complications, and this reform should contribute to solving this problem. This discussion will be led by Noel Camilleri, a legal advisor of the Ministry of Economy, Investments and Small Businesses of Malta.
Final panel of what, in my opinion, and I am sure you will all concur, has been a very interesting and enlightening conference, not only on the current trends of intellectual property, but also with the ultimate objective to try to, as the conference title itself declares, shape the future of intellectual property. This is also being discussed in the light of the proposal put forward by the Commission for the modernization of copyright, a proposal which has been described as very complex and yet interesting to meet the present and future demands of copyright without in any manner dismantling what is today still considered as valid. The topic of this panel is limitations, exceptions, limitations, which many consider presently to be fragmented and vary throughout the EU, making it more difficult to resolve differences which arise within the digital single market. In order to give us a good and learned perspective on this important aspect of copyright, it is with my great pleasure to introduce the three highly esteemed members of this panel, who are Professor Michel Walter, Professor Silke von Lewinsky, if I pronounce it correctly, and Dr. Leonora Rosati. Dr. Rosati is an Italian qualified lawyer with experience in the area of intellectual property and internet law. She is an IP law lecturer at the University of Southampton, a guest lecturer in copyright law in EDHEC Business School in France, and an editor of the Journal of Intellectual Property Law and Practice published by the Oxford University Press. She also runs her copyright law and public consultancy. Dr. Rosati will focus her intervention on the subject of copyright exceptions to CJEU judgments. She will also examine and search for flexibilities or inflexibilities dealing with the rationale and objectives of the InfoSoc directive, and in particular, the exceptions and limitations. The next speaker will be Professor Silke von Lewinsky, who is tenured at the Max Planck Institute for Innovation and Competition Munich, and specializes in international and European copyright law. She's adjunct professor at the University of New Hampshire Law School and assistant professor at Zagreb University. She has been the chief legal expert consulting the governments of Eastern and Central European countries on their copyright legislation in the framework of the EU's programs. Her book publications include the WIPO Treatise on Copyright and European Copyright Law, which she has written and edited with Professor Michel Walter. Silke is also a frequent visiting professor in numerous universities worldwide, including University of Melbourne, Columbia University School of Law, and DePaul University in Chicago. She is also vice president of the International Literary and Artistic Association and a member of the editorial board of the Copyright Society of the USA. Silke will mainly deal with Articles 4 and 5 in relation to the question of competency, lack of internal market issue, and free movement impact. She will question whether a different greater plan is behind this approach and what this means for WIPO discussions. In her presentation, Silke will also refer to the aspect of remuneration. Finally, we'll have Professor Michel Walter, an honorary professor at the Vienna University and visiting professor at Danube University in Krems, specializing in intellectual property rights and in particular copyright. Michel is a practicing lawyer in Vienna, president of the Austrian group of ALAI, and co-editor of the IP journal Media and Law. Professor Walter is a well-known author of numerous articles and books, in particular on national, European, and international copyright and related rights, such as European copyright, a commentary he added with Silke von Lewinsky. Michel will be focusing on the Commission's proposal as far as the exceptions and limitations in the strict sense are concerned, in particular with reference to Articles 2, 3 to 6, dealing with text and data mining, digital and cross-border teaching activities, and preservation of cultural heritage. We'll also concentrate on questions of principal importance, such as the elastic circumscription or exhaustive list of exceptions. So as you can see, three very interesting aspects of exceptions limitations by three very highly respected speakers. And I will start by inviting Dr. Eleonora Rosati to make a presentation. Eleonora.
Good morning, everyone. I would like to start by saying how thankful and honored I am to be here today to discuss indeed the future of intellectual property in Europe under the umbrella of the Slovak presidency of the Council of the European Union. I would like also to thank Noel for the kind introduction. And in the time at my disposal, I thought of moving a bit away from what is indeed the topic of the day, that is the copyright package recently proposed by the European Commission, to focus on the case law of the Court of Justice in the area of exceptions and limitations. And I'm going to do that to assess also the novelty that is contained in the copyright package as far as exceptions are concerned. That is the fact that unlike the model adopted under the Information Society Directive, now the European Commission, in the context of its proposal for a directive on copyright in the digital single market, is moving towards a model of exceptions and limitations that are no longer optional in character, but are indeed mandatory for member states to implement into their own national law. And in particular, the question that I have in mind and I would like to address is whether this new approach to exceptions and limitations, one of mandatory character, could be reviewed for possible extension also to other areas of copyright exceptions, and in particular the exceptions that are currently envisaged by the Information Society Directive. And as a title of my presentation, I've stressed the fact of inflexibility, because it seems to me that, especially in recent years, the Court of Justice of the European Union has pushed for further harmonization in the area of exceptions and limitations, and in some instances this has resulted in the quashing of a number of national exceptions and limitations. It is sufficient, for instance, to think of the Dutch private copying exception that was tackled in the Asi-Adam case, or more recently, for instance, in the Dekmin judgment, the Court of Justice of the European Union said that the additional conditions that Belgian and also French law to some extent envisage would not be really compatible with EU law. So what I would like to do is to start really from the beginning of time and recall what rationale and objectives the European Union legislature wished to pursue by adopting the Information Society Directive, and then focus indeed on the relevant provision in the respect of exceptions and limitations, this being Article 5, and to see how in recent times the Court of Justice has pushed towards a greater inflexibility in order indeed to have exceptions and limitations that look more homogeneous than what has been the case until recently. So, starting with the Information Society Directive, I chose to infringe copyright in the Wizard of Oz because, indeed, by adopting the Information Society Directive, there was the expectation that many of the problems that copyright was facing at the end of the 1990s will be solved. Finally, there will be harmonization, and finally, indeed, goods and services based on or incorporating copyright-protected content would circulate freely in the territory of the European Union. The directive harmonizes a number of aspects of substantial copyright law, starting with exclusive rights and related exceptions and limitations. What is interesting as far as the relevant provision on exceptions and limitations is concerned is that with the exclusion of the exception for temporary copies, Article 5 sets a list of optional exceptions that member states are free to implement or not into their own copyright laws. And this freedom is not just limited to the decision whether to have these exceptions, but in some instances there has been also the belief that member states had also the freedom to determine the scope of the resulting exceptions and limitations. And in all this, looking again at the structure of Article 5, the overarching limit is the one of the three-step test that until recently has been considered a bit of a theoretical issue as far as exceptions and limitations are concerned, and in more recent years, indeed, the Court of Justice has instead clarified that the three-step test has a biting force as far as the understanding of exceptions is concerned. And the overall rationale of the Information Society Directive was the fact that differences in the laws of member states would prevent the proper functioning of the internal market, both as far as economic rights and exceptions and limitations were concerned, and overall an harmonization was needed under the umbrella of ensuring a high level of protection of authors and right holders. And of course, there was also another more institutional aspect that was to implement into the EU legal order the 1996 WIPO copyright treaty. However, despite the huge expectations surrounding the Information Society Directive, the overall evaluation has not always been positive. There have been commentators that have called the Information Society Directive as compromise-ridden, as having failed to increase legal certainty, and at the end of the day, being a total failure as far as harmonization is concerned. And from a first reading and look at relevant national implementations, this indeed appears to have been true, because there have been situations in which member states have had fairly different implementations of the Information Society Directive, both as far as exclusive rights are concerned, but also exceptions and limitations. But if this has been what has happened in practice, now the question that has arisen in more recent times is whether what has happened is indeed correct from a legal standpoint, or whether instead the Information Society Directive had a stronger harmonizing force that member states failed to acknowledge when implementing it in their own member states' laws. And the answer seems to be in the positive, and this is particularly apparent from a recent case law of the Court of Justice of the European Union, both in the area of exclusive rights. It is sufficient, for instance, to recall the decision in Svensson, in which the Court of Justice clarified that exclusive rights should have the same scope across Europe, but is also true as far as exceptions and limitations are concerned. Article 5 has been called by some commentators a shopping list. You can, like a supermarket, go there, pick from the shelves what you like, and then when you are at home, that is back in your own member state, you can cook the stuff as you please, and the result is an exception that has differing, divergent boundaries depending on the legislation considered. This has been the case for a number of exceptions, private copying being a primary example. Indeed, it is difficult to speak of an EU-wide private copying exception, but has been also the case, for instance, of parody more recently, and also quotation, for example. And in recent years, the Court of Justice seems to have adopted a less tolerant approach to these differences. And besides highlighting the obvious, that is, that exceptions and limitations, being a derogation to the general principle of copyright protection, should be interpreted strictly, has also used the three-step test in order to quash, for instance, the Dutch private copying exception, holding that an exception that would allow one to reproduce copyright works from unlicensed sources, read peer-to-peer over the internet, would be against the three-step test. But more recently, there has been an insistence of the Court of Justice to hold that some concepts in relevant exceptions and limitations should not be interpreted as referring to the national situation at hand. But when there is no reference to member states' laws, the concept that is to be found in Article 5 should receive an autonomous interpretation of EU law, and therefore, for instance, the concept of parody should be interpreted not with regard to Austrian, Slovak, or Italian law, but should be the same everywhere across the European Union. And in addition to this, not only the insistence of the Court of Justice for an interpretation of exception that will be EU-wide, but also an insufferance towards national approaches that would define the scope of national exceptions in an autonomous fashion. And indeed, the first clear statement in this sense is to be found in the decision of the Court of Justice in Padoan concerning the private copying exception, in which the court said that it is not acceptable that member states define in an harmonized fashion the scope of exceptions and limitations that have been derived from Article 5 of the Information Society Directive. This has been also the case more recently in relation again to the private copying in DECMIN, but also in relation to parody, in relation to private copying in ASI-ADAM, and in relation to parody in the DECMIN decision. From this string of case law, there is a number of conclusions that can be drawn. The first one is that for sure in Article 5 there are exceptions and limitations that are not just categorically worded prototypes, but if one follows the Court of Justice interpretation, require indeed member states not to add additional requirements and not to decide independently what scope the resulting national exception would have. Of course, from a broader perspective, leaving less room for member states' freedom might have some advantages. First of all, the fact that one would reduce the transaction cost associated with implementation, because you will know already what language you have to use and you will not have to think about additional conditions. But above all, having more harmonized exceptions across Europe would allow the creation of this internal market with which both EU legislature and possibly even more the Court of Justice of the European Union have been particularly concerned over the past few years. Because of course you might have copyright works that circulate especially now over the internet, and it is important that the scope of protection is clear a bit everywhere in the territory of the European Union. So from this quick overview of recent case law of the Court of Justice, it seems to me that moving now to the debate that is being undertaken in Brussels, a question might be whether we need new mandatory exceptions, as has been indeed the position of the European Commission, or what we need is more homogeneous exceptions. The two are sides of the same coin. That is, to ensure that there is indeed an internal market where there is a real freedom of movement for copyright protected content. And coming to a conclusion, and now looking into the proposal of the European Commission, it is, I think, arguable only to a certain extent that these new mandatory exceptions aim just at clarifying a situation that is already allowed under the law. This new text and data mining exception, cross-border teaching activities, and cultural heritage preservation indeed create a new law. And the question that becomes is whether the current reform debate should be limited just to these very specific instances in which mandatory exceptions are considered necessary, or whether instead we should have a broader discussion, possibly now also in the context of a parliamentary debate, as to whether the model that is being proposed of mandatory exceptions in the context of the new proposal for a directive should be extended also to the existing exceptions under the Information Society Directive. That is, whether a discussion of more homogeneous exceptions, if not mandatory exceptions, should be part of the broader discussion around exceptions and limitations in Europe, and not just in the context of text and data mining, cross-border activities, and cultural heritage. And then, as a final point, while I think it's clear from what I've said that I would welcome such a discussion, the final question is whether this discussion should be left to the Court of Justice of the European Union, which appears particularly keen to conduct an assessment of this kind, or whether instead EU policy and lawmakers should have a discussion around a reform of exceptions and limitations in a broad sense, that is also by looking at those included at the moment in Article 5 of the Information Society Directive. And with this, I would like to conclude, and thank you for your attention. I look forward to the thoughts of my fellow panelists.
A very interesting presentation and a very important question that maybe we'll have time to discuss here. Thank you, Eleonora, for such a presentation. Now I'll invite Professor Silke von Lewensky to do her presentation. Thank you.
Thank you very much, ladies and gentlemen. Good morning, and also from me a very warm thank you to the Slovak presidency for having invited me to speak here. I will start with a general remark. On a positive side, I know how difficult it is these days for the Commission or any legislator to propose legislation in the field of copyright, especially on harmonization. In today's environment where everything is controversial, where you have so many different interested parties with different interests fighting strongly for their own positions, so there's not any possibility to propose anything which would make everybody happy, I believe. And I also acknowledge the pressure coming from all these different sides, first on the Commission, now on the whole EU legislature. To write it this way or this way. So for the start, something good to say. I believe that in principle, the approach of the Commission to look for targeted specific issues to regulate is much better and more realistic in any way than trying to reinvent the wheel and to make a big reform. And by the way, I agree with what Maria said yesterday, that I don't think that the case has been made for a need to reform totally the European or any other copyright. We have to address particular problems where they arise. And as one may, that's my second good remark, as one may see also from the current proposals on the table, the Commission obviously tried to give everybody something to make him or her happy, so to present something in a way balanced overall. Still, of course, I also have to make some remarks. First, again, critical remarks of a general nature. We do have a considerable amount of papers on the table now, and many of them are very difficult, very complex, and also from a legal point of view, very technical Plus, they often address things which go deep down to certain practices, such as text and data mining. That's an area which the normal copyright lawyer has never been acquainted with before it occurred, and certain practices have already arisen in the business. So I think you need a lot of time to study what is there already and what would be the implications of any legal regulation in such fields. So in general, I think we need a sufficient time, appropriate amount of time to properly reflect all these proposals and study them, and also look at any possibly broader or principal implications of a more general nature which they may have, so as to take decisions in the end, and that's of course addressed mainly to the member states, take decisions which would create sustainable outcomes. So there's no rush at all, and I hope there will not be exercised any pressure for rush on those who are responsible to make these decisions. Except maybe in a very particular case where there is damage kind of being imminent, possible damage. That's the matter of Article 12 on the sharing of the remuneration from private copying, etc., between publishers and authors, due to the consequences of the reprobel decision of the European Court. I think here it would be good to have a fast solution in order to avoid damage caused by this decision. But now on Article 4, the teaching exception, and a little bit on Article 5, the preservation copies, only some remarks. First, I think it's good that they are rather precise. That corresponds to the first condition of the three-step test. And the criticism or the question which I would have is, well, in the teaching case, do we really need a mandatory limitation here where only local acts are concerned? And I believe in this area most acts covered, most uses in teaching are still local and will probably remain local for a long time. And this issue touches on competence issues and subsidiarity. I think a case has not yet been made to show that it is really necessary to have a mandatory limitation there. We talk mainly of even local digital uses, and I believe the Article 4 addresses not only cross-border uses, as the title says, it says digital and cross-border uses, and also in the recital 5, for example, you see that cross-border is only mentioned as a case, in a particular, so it says in particular cross-border uses. So again, digital reproduction occurs in one country. It is a local act. Many acts of digital communication, for example, when a teacher transmits works by the intranet to his students, they are usually students in his local school. This is usually also done in the local language. I don't see a big demand for having Bulgarian teachers having cross-border teaching to pupils in other member states, for example. So at least at the school level, most uses will be local in local language, obeying local curricula set by local ministries of education. So I think there is really a lack of an impact on the free movement, and thereby also on the internal market, and thereby on the competency. There could be cross-border teaching, of course, more at the university level, although even there I'm not so impressed by the impact assessment saying that maybe 80% of universities are thinking to do such cross-border teaching. That's certainly not by itself making a case. By the way, I have been many years ago teaching, when I was teaching already in Franklin Pierce Law Center in the USA, we already thought of having cross-border teaching, and then the result was, well, maybe in one or a few cases, but face-to-face teaching is still considered the main and most efficient way of teaching, despite knowing this technique. So I'm not sure whether this will be the main way of teaching in the future, even at universities. The Commission also refers at legal uncertainty of Article 5. Okay, then what you could do is, of course, render Article 4 of the proposed Information Society Directive, sorry. This can be the case, but then it would be sufficient to render Article 4 of the proposal into a facultative provision explaining what is permitted under the relevant exception under Article 5 Information Society Directive. I think member states may, in this context, want to consider that with a mandatory provision, they would disempower themselves for the whole future, meaning they would give up their current flexibility under Article 5 of the Information Society Directive, their flexibility of regulating their business at home, of regulating what happens in their national market only, such as most cases of teaching. They would no longer have the possibility to react quickly by national legislation to new challenges by adapting this such educational teaching limitation by themselves, but they would have to do this together with all other member states, and that is a major effort. They might also consider whether and what possible consequences a mandatory provision might have on international discussions going on in WIPO. So I think due to this lack or negligible impact on the internal market, one might propose to have a twofold provision inside Article 4 of the proposal, namely to say, specifically for cross-border teaching uses, the limitation is mandatory, and for all other local uses, it would be a facultative one, interpreting what is allowed under European Union law as a limitation. That would be a possible way to deal with these issues. Now, briefly on Article 4, second paragraph on the remuneration. No, sorry, that is first the licensing. It says that it's, member states may provide that if there is an adequate license, then they don't need to have the exception. I think one has to look, especially in the teaching area, to the fact that we do have material which is created only for the educational market, school books, etc. And this is the primary market for these products. And I think having an exception for these kinds of products would affect the normal exploitation, because there's no other really way of exploiting these works, and therefore would be arguably in conflict with the second step of the three-step test. So for these kinds of works, I think one should even not have a limitation in the first place. On the availability of adequate licenses, I suggest to clarify that this should mean that the mere offer of such a license, an adequate license, should suffice. Because if you say, like the European Court in the Eugen Ulmer Technische Hochschule Darmstadt case, that it is necessary that there has already been an agreement on a license, then this will be an obsolete provision, because no user, no teacher would, a school would want to enter into such an agreement if he knows, well, if I don't do so, then there is an exception. So I think we have also a similar system in the UK for many limitations, that if a license is being offered, which is adequate, this should exclude the exception. And I think there's a clarification useful if one wants to take this road. How much time have I left? Okay, then I will skip Article 4.3, which maybe Michel Walter will say something, which is in a nutshell, that I think one should not follow this solution of the Satellite and Cable Directive of, well, the country of origin principle, and especially where there is a mandatory exception. I think there's, or where there is cross-border use and a mandatory exception, there is no need for this provision anyway. I have no time to develop this, but and one should also think whether this could be a precedent for larger extensions of this principle, so to say, which might be more damaging. On the remuneration, one point only, I think it talks of fair compensation. This was, of course, a compromise. It was taken from the Information Society Directive. This wording, fair compensation, was a compromise in favor of the United Kingdom, which didn't like to have private copy remuneration and probably will never need to have that anymore now. But since we are unfortunately seeing that the UK will leave us, maybe that is, on the other hand, the chance for the rest of the member states to get back to their traditional concept of equitable remuneration for private copying and the like uses, which is more or less the traditional way of seeing things on the continent, and to kind of call it also equitable remuneration, and to delete this concept of harm, which came in the same context, which again doesn't comply with the concepts under continental European laws. On cultural heritage institutions, my main point is again that these are mainly local acts. I don't see the internal market impact, and therefore not the need to have a mandatory exception. If it is proposed, I just wonder whether there is some other aim behind, but I don't know which one. One has to think about it. And one thing on terminology. It says cultural heritage institutions. It's maybe a little bit misleading. It sounds as if it is about heritage, old stuff only, but actually it would potentially cover everything which is newly bought or not so old, what is current copyright works. So just as a little hint. I don't have time to talk about electronic lending, but maybe in the discussion period. Thank you very much.
Another well-thought presentation, and obviously I leave the final word to Michel for his presentation. Please, Michel.
Thank you very much, Chairman. Thanks to all of you that you are still here to listen to the last presentation of this day and the discussion to follow. Thanks to the organizers who have put up copyright issue already at a time when the Commission not yet had tabled its copyright package, so-called. So it's a difficult task to be the last speaker, day number 1 after Trump. After having listened to plenty of very pertinent presentations already, I'll try to do the best out of it in my very best English, which dates from a time to take up a joke by the German of the first panel when Mr. Begevin was 2 years old only. So I try to do my best. As was already discussed yesterday afternoon, the copyright package tabled by the Commission is dealing with a series of very important questions relating to copyright and related rights. What was not explicitly alluded to yesterday was the step taken by the Commission in regard of fair remuneration of authors and performers, and in the context of authors' contracts, as well as the participation, Silke mentioned it already, the participations of publishers in the proceeds from the claims to an equitable remuneration. In my personal view, this initiative of the Commission is to be welcomed, but deserves into-depth analysis and discussion. In my personal view, the steps taken must be elaborated further and show to be a little bit overcautious. But it's not a focus to which this panel is dedicated. We in this panel are expected to focus on exceptions and limitations, namely regarding text and data mandate, it was already repeatedly referred to, digital cross-border uses for teaching purposes and preservation of cultural heritage. As to these three new exceptions, the Commission's proposal suggests, as has already been mentioned again, the establishing of a special regime for certain uses in an independent instrument outside the Information Society Directive and on a mandatory basis, which is quite new given that, as has been referred to as well already, the exceptions and limitations showing up in Article 5 of the Information Society Directives are based on optional, on an optional basis only. In this particular context, I would first like to touch upon the question again of more general interest, namely, first, the question of whether more specific exceptions should be defined in an independent instrument at all, or rather be enshrined in the framework of Article 5, in particular, of the Information Society Directive. Secondly, I will again raise the question of whether such new exceptions should be optional or mandatory. And in concluding, at the risk of some redundancies, I will address the question of equitable remuneration again. Preliminarily, it must be mentioned that the Commission does not propose a more general circumscription of one or the other of the exceptions, according to the model called fair use, as all of you know. So I think this approach of the Commission is to be welcomed, though many user circles and some of academics advocate such more open attitude again with regard to exceptions and limitations. Getting to my first point, the question is to be answered to whether the new exceptions should be set out in an independent instrument, as the proposal suggests, or rather should be enshrined in the framework of Article 5 and other related earlier directives. Indeed, seen from an academic point of view, the dealing with the exceptions on issues should rather be included in the existing framework. This way, also the consistency with the acquis could be attained more easily. On the other hand, however, for practical reasons, the approach taken by the proposals appears to be preferable and corresponds to the approach which has already been taken with regard to orphan works in the Orphan Works Directive. Or, to speak more frankly, it would indeed be appealing to bring the complete shopping list of exceptions in line with the digital age and to harmonization, also in regard of other subject matter Professor Leistner alluded to yesterday, for instance, the database directive. However, it must be taken into consideration that such comprehensive approach could turn out, how shall I put it, difficult. So in my personal view, the more cautious steps suggested by the Commissions appear preferable. However, if the new exceptions must not necessarily be embedded in the framework of existing directives, it should be carried out in full compliance with the acquis, which is why we will have to look rather cautiously at the exceptions proposed in order to ascertain whether there are deviations from the acquis, and if this should be the case, whether such deviations are indeed well-founded. So I think, given the time constraint, I will skip some comments I prepared on text and data mining. And come to my second point, which is the question, should these new exceptions as suggested by the Commission be mandatory or not? So I think this is the very core issue of the whole proposal as far as exceptions and limitations are concerned. And as far as regards this issue, a careful evaluation between the aspect of harmonization on the one and the subsidiarity principle on the other is necessary. As Silke has pointed out already, also the question of competence has to be taken into consideration. With this regard, I can only utter the well-known sigh, "Two souls, alas, are dwelling in my breast." Of course, on the one hand, if one advocates pushing forward harmonization, indeed, mandatory exceptions could be taken into consideration. However, this approach would be in conflict with the acquis. This all the more since there are no major differences to be ascertained in comparison with the other exceptions as set out in Article 5 of the Information Society Directive. Optional exceptions, therefore, would better fit in with the acquis, which is why mandatory exceptions in principle should only be taken into consideration where urgently needed. And is the very question to be answered too, as Silke has already alluded to. In my personal view, there is no compelling need for such mandatory exception in all of the new exceptions proposed by the Commission. This in particular with respect to the fact that there is no significant cross-border use to be expected. However, as already mentioned, if one advocates to drive further harmonization and to establish a set of harmonized mandatory exceptions along with the optional exceptions already enshrined in the earlier directive, one could agree to the proposal's approach on the condition that such mandatory exceptions comply with the basic guidelines as anchored in the existing directives already. To come back to the question of the teaching exception, as far as cross-border teaching activities are concerned, the proposal obviously assumes a significant cross-border use. If this should be the case, this would be another argument in favor of such mandatory exception. However, in my personal view, the proposed satellite cable analogy with this context, according to the third paragraph of Article 4, appear to be unnecessary, since the exception proposed is rather detailed and well-defined and does not leave much leeway for national legislature. If, however, an optional approach should be taken eventually, the fictional approach taken in the Satellite Cable Directive should not be retained, as again Silke mentioned already, since this may cause misunderstandings with several respects. In my view, rather, it should be simply stated that the use for teaching purposes may be carried out cross-border as well into other member states or contracting states of the EEA, irrespective of whether these member states provide for such exception or not. In concluding, and I think it's time to conclude, I would like to touch upon an issue Silke referred to as well already, which appears to me of great importance, namely whether the new exceptions to be established on the EU copyright level should indeed be established without setting out explicitly and mandatorily a claim to an equitable remuneration. The proposal does not anchor such claim and only leaves it up to the national legislature to provide equitable compensation as far as digital cross-border teaching use is concerned. To the contrary, as far as text and data mining is concerned, it stated explicitly that the harm inflicted to right holders is minimal and does not need to be compensated. With this regard, it must be taken into consideration that the referencing to the harm inflicted to right holders falls short, in my personal view, and refers only to one of the three criterion which has to be taken into consideration in view of the three-step test, which, as all of you know, is enshrined in the International Copyright Treaty as well as at union level in 5.5 of the Information Society Directive, as well as in Article 6 of this proposal. The referencing of the harm, it must be added, obviously stems from recital 35 of the Information Society Directive and the pertinent judgments of the Court of Justice of the European Union in the first line, the Parwan case. But if you read this recital and the respective judgments of the court carefully, the idea of compensating and rewarding of authors for the use made of their creations turns out as another important aspect, which is to be taken in consideration as well. I quote, "In certain cases of exceptions or limitation, right holders should receive fair compensation to compensate them adequately for the use made of their protected works or as a subject matter." In my view, therefore, contrary to the proposal, fair compensation is to be provided for all of the proposed new exceptions, TDM included, since this seems to be a rather intense use made of others' creations and as a subject matter of protection, which must be rewarded at least in some way. As to the teaching activities alluded to in the proposal, again, contrary to the proposal's concept, the claim to an equitable remuneration or compensation must be provided for mandatorily, in my view. This all the more with regard to the large scope of this envisaged exception as set out in the proposal. By the way, the hint to the freedom of member states to provide such equitable compensation appears to me to be a matter of course. To the contrary, such mentioning causes the danger of misinterpretation on the grounds of an arguing a contrario. Let me make a last short point. The proposal, for good reasons, underlines the high level of protection as envisaged in EU copyright and underscores that such high-level protection is important for, I quote, good functioning of the internal market and the stimulating innovation, creativity, investment and production of new content and so on, also in the digital environment. However, it is not only this utilitarian idea which should apply, but also the idea of rewarding authors and other right holders for their creativity, as has been put explicitly in earlier directive. I would only like to mention recitals 9 to 12 of the Information Society Directive, and I quote, "If authors or performers are to continue their creative and artistic work, they have to receive an appropriate reward for the use of their works, as must producers in order to be able to finance their work," and so on and so on. Adequate legal protection of intellectual property rights, therefore, is necessary in order to guarantee the availability of such a reward and provide the opportunity for satisfactory returns on this investment. So we shouldn't lose out of sight this Magna Carta of modern copyright, as I would call it, and should transfer it also to the proposed digital single market directive as well. So I've come to my end. Dziękuję wam za pozorność. Thank you for your attention.
So thank you, Michel, for a very interesting presentation. The Slovak organizers have asked me to invite Lizette Kalsoven, if I'm pronouncing it correctly, from Kennesland to do a presentation.
Yes, thank you very much. Oh, yes, I have a thing as well. Thank you very much for the opportunity to be the first to... Oh, is that your watch?
No,
oh. We need to be able to keep time. For the opportunity to first speak after this very interesting panel. Thank you all very much for your presentations. I'm here to share very briefly about a resource that Kennisland developed over the past few months that I think will be of use of some of you in this interesting few months, if I may say, about surrounding the copyright reform. And it's called Copyright Exceptions. So you figured why this would be the good panel for me to start talking about it. Kennisland is a think and do tank for social innovation. We are based in Amsterdam. And we've been involved in the copyright reform discussions for, I think, more than a decade now. And we see a great need for evidence-based policymaking, to know what the situation is before you start arguing for new rights, be that exceptions or limitations or otherwise. However, we couldn't find a well-researched, good available resource to show us what the exceptions and limitation situation in Europe is today. So while there are some studies that have been performed in the past about the implementations of the Information Society Directive and more recently the Orphan Works Directive, they were mostly outdated and incomplete and also sometimes disputed. So we set out to correct that, and this is the result in table form. Here you see all the Information Society exceptions and limitations, and on the bottom you can see the Orphan Works. On the top you can see, of course, all EU member states, and a simple high-level summary of do they have that exception, do they not, or do they have it partially, of course, in green, orange, and red. As you can see, one member state has implemented all Information Society Directive exceptions and limitations, which is Malta. Other exceptions and limitations are far less popular, and some are partly. Again, this is a very high-level summary, so it's not that green means that, that the exception has been transported word by word. If you zoom in a little bit more, this is the Dutch implementation, if you will see. You can also have more information on how the actual exception has been implemented. So it refers to the national law, if available with a link or with the full text. And it also includes, where possible, relevant jurisprudence. So for example, the private copying CGU discussion has been noted on top there. So you can also see that. This has been pulled together from using old research that's being done back in 2007, also more research, internal research being done by private companies such as Google, and by asking experts from all member states to check whether this is actually correct. And we keep updating this database, of course, because sometimes new information becomes available, sometimes the law changes. So if you see something in that table where you're like, I don't think this is right, please do send feedback through the feedback form on copyrightexceptions.eu, because we very much welcome it. And also, if you have more information, such as relevant jurisprudence, do get in touch. We want to keep this as updated as humanly possible. And of course, we also made some conclusions based on that table that I'll go back to, is that exceptions and limitations in Europe are far from harmonized, as it was also in the preamble of this panel, of course, and that we see a need for further harmonization, because now we have a copyright system that is supposed to be a balance between creators' rights and users' rights, and we have very harmonized creators' rights, but very unharmonized users' rights. And also within the current copyright reform proposal on the table, they only address the areas where relative harmonization is already in place. So, for example, through the reproduction exception that's already implemented to a certain extent, I have to say, not well in all member states. So it's already pretty much there. What we need is more harmonization in the more interesting colored bits, if I would say. We're not there yet. We need more harmonization because I think we need to reevaluate that balance between creators' rights and users' rights. I hope that you will find Copyright Exception Study a useful research to help you figuring out what the situation is right now and how we can build farther on the situation. And if I may end with a question for the panel. This is, for example, the private study exception. The panel has mentioned a couple of times that perhaps we don't have a need for some mandatory exceptions, not new ones, or an unharmonization of the existing exceptions might also not be needed. So my question is, if you are right in this, how can we then still get that balance right? So if the solution is not in mandatory exceptions, what is it then, how we can get the balance between copyright right again? Thank you very much.
Thank you so much, Lizette. So I'll leave first question. Silke? Please. Yes, this one. Yes.
Okay, simply, the member states can get this balance right, and it's their competence to decide according to their own policy decisions where exactly the balance is. I think this kind of table is always tricky because it suggests, because not all of them have all these limitations, that this would be would require that everybody has them. Harmonization is not an end in itself. I think we should see that also the cultural diversity issue is one principle in the EU, and that lots of things may be and are to be left to the member states, and they may have different policy decisions or that they want to make. And I think there's no automatic kind of procedure to say, well, we see these and these countries don't have these and these limitations, that's why we need to have them all. That's not an end in itself. It may be left to the member states to say, in our country, we don't feel this need for whatever reasons or not in the same way. And also I still object this concept of users' rights. There has even been a habilitation in German law analyzing that very much, stating that, well, I know some people don't like to hear that, but it's still true that the intellectual property right is a property right because the author can prohibit and authorize. That's like for the material property, the same privileges. And that is the principle. And the user has certain freedoms under the law. So I would, and getting the right balance is only a second kind of, when harmonizing, then the balance has to be taken into account. But there's not the primary task for the Union to have a copyright as such or have a balanced copyright. The competence is still limited to solving the cross-border problems. Thank you.
Do you want to intervene?
I'm in favor of having more harmonized the exceptions, so I think that on this point we agree. And if we look at the proposal, for instance, the cross-border teaching activities, in my opinion, fails to provide more harmonization because despite being mandatory, leaves member states the freedom to say that perhaps if there are licenses in place for certain uses or works, we don't need exception, and leaves them free to decide whether to have a fair compensation requirement. So you have something that is mandatory, but then how you implement it, there is certain freedom in this respect. So if you say these exceptions should not be mandatory and member states should retain some freedom, so buying this argument, I think that ultimately, more than national legislators, the task is upon the courts to provide this balance. And in the UK, there is the concept of fair dealing, within which certain exceptions are framed. Mr. Justice Arnold has issued a number of judgments in which he has indeed provided this balance. And then if you look also at the Information Society Directive itself, the three-step test, that has been held to be addressed at the member states legislators, indeed they can also be used by courts when deciding specific cases that relate to the balance between copyright protection and exceptions and limitations. So ultimately I think that also judges will play an important role in providing this balance.
This one, thanks. Only a brief further comment. I fully agree. Of course, there must be a balancing of interests of right holders on the one hand and consumers or users, or however you would like to put it, on the other hand. But the question is where this balancing should take place, on the European level or on the level of national member states. So, under the perspective of the acquis, it is a clear answer to the question. The balancing should be carried out within the framework, the great framework of, in particular, Article 5 of the Infosoc Directive, on the national level. Of course, as I mentioned already, if one advocates more or less full harmonization on the European level, one has to take into consideration the balancing and reopen the whole Information Society Directive, which might turn out not only difficult, but dangerous. My personal opinion.
Thank you, Michel. Any more questions? Yes, please. Please state your name and your organization, if it's possible. Thank you.
Good morning. My name is Anne Bergman-Tau, and I'm the director of the Federation of European Publishers. I represent book publisher, and I look forward to spend my weekend, instead of mourning what happened on the other side of the Atlantic, to look at the Kennisland complex construction. There's one thing I think you forgot, though. I think it's licensing. They may be in a number of countries. I'm thinking of the Nordic country. I'm thinking of the UK or Ireland. There's a number of voluntary licensing system or extended collective license that provide the same results as exception, and that have fitted perfectly in the landscape of those countries. That I'm not aware that in the Nordic country this is being questioned, by example. So I think that I will take the liberty of using your answer formula or whatever it is to just point out that there might be solution, and I would agree harmonization is not an end in itself. What is the end in itself is to make the system work, is to allow teachers to be using material. And when you're an educational publisher, your only market is education. And therefore, you need to strike the right balance. If there's an exception, furthermore, without any form of compensation, remuneration, then what is your incentive? What is the incentive of your educational authors to publish books? Therefore, I think that you should also add the licensing solution into your landscape.
Thank you for a statement. Any other comments, questions to the panel? Yes, please. First row, please. First row.
Thank you. Thank you. I know we.
Sorry. Can I, before you reply, there was a question from.
I'm so sorry.
From
I already got
first row, please. Thank you. It would be preferable that questions are made, rather than statements, questions are made to the panel, please. Thank you.
Okay, I actually have a question for the panel, and in particular for Professor von Lewinsky and Professor Walter. So I completely agree that there is argument for cultural diversity, and even tied together with the subsidiarity of the European Union in policy making, and there might be definitely certain exceptions that might be more needed in some countries and more culturally engraved. And definitely harmonization is not a goal in itself, but then it makes me wonder, if you believe that a cultural diversity is so important, isn't that also going against the closed list of exceptions and limitations at the first place? Because that also already harmonizes the room for the member states where they can do the balancing exercise. And arguably some member states may be willing to go beyond, but they cannot, because they're constrained. What do you think about this from the perspective of the cultural diversity argument? Thank you very much.
Okay. There you give me the chance to come back to this argument of Hugenholz that the harmonization of limitations would have been a failure, which I disagree with, because what Article 5 does with the facultative limitations is to give the outer framework of what actually defines the scope of the rights, the minimum scope of the rights which must be granted. It's the other side of the right, so to say. That's why you have to have that as the outer limit to define the core contents, or the noyau dur in French, of the right provided. And because otherwise you would not have any harmonization at all. So it's just the outside scope to define actually the right up to where limitations can be made, and in which so the flexibility for the limitations is there, but the outer framework given by the limitations are at the same time the limits to until where you can limit the rights, and therefore it is kind of a necessary counterpart of, if at all you harmonize rights, then you need this.
You want additional comments, Michel?
Only a single word. Good question, of course. Very good question. But it was and is an intermediate solution. We have some harmonization, but we have not full harmonization. If we do not advocate full harmonization, then we could open the list and every member state can do what is balanced under this perspective, balancing right holders' rights on the one hand and users' rights on the other hand. So it's an intermediate attitude taken. In my personal view, for the time being, we should stick to this solution. But of course, it's a point of discussion.
The question I don't think was addressed at me, but just a final dream, like the Commission itself mentioned in the digital single market strategy. The long-term dream is to have full harmonization. So I'm sorry, cultural diversity, but I think that is a solution that at the end of the day will be inevitable, and I think it will make things work better than what is the case now. Because if we are speaking about an internal market, that is not just for trademarks, no, but it should be also for copyright protected content, especially now that content is increasingly enjoyed, exploited, and infringed across borders. So at least in the EU, there should be a unique approach.
Thank you. So, if you want to make a comment, but a short one, please. Okay, right. Any other question? Thank you. Any other questions? Or yes, please. Madam.
I just want to make a very quick comment. The functioning of the internal market does not require full harmonization. I mean, the discussion is more complex, but I think when we put the options in white or black, the whole list or not the list. There are a number of exceptions in Article 5 of the Infosec Directive that to start with you wonder what's the point of having them harmonized, but we can make an internal market function on the basis of sufficient harmonization without having to get to full harmonization. I think that is something we need to keep in mind. It's a very old form of making the internal market work. It doesn't come only in copyright. There are points such as minimum harmonization, mutual recognition, country of origin. You do not need full harmonization. I think full harmonization is something that will be beyond what is proportionate and necessary in order for copyright to harmonize. It's part of the discussion.
Thank you, Maria. Any other comments or questions, please, to the panel? No. Okay. So before I end, I'm sure you will agree that a round of applause is merited to the three speakers here for such a very, very knowledgeable presentations. Finally, before we wrap up this part of the conference and pass on to the organizers, please allow me, on a personal note, to thank the Slovak presidency for inviting me to act as a mediator. It was a great experience and privilege to participate in this exceptionally organized and intellectually challenging conference. And may I also ask you to give the organizers a merited round of applause.
Thank you very much. Thank you, ladies and gentlemen, for your presentations. And thank you, Mr. Camilleri, for leading this, our last panel. And now I would like to ask you to take your seats. And you, Mr. Camilleri, please stay here, because I would like to invite here other panel moderators to summarize these 2 days very briefly before lunch. So if you'd be so kind. Thank you.
Okay. So, this is it. We are nearing the end. And this is actually very unexpected. I didn't know that I'm supposed to summarize, which is now, of course, a huge burden because I had this many great speakers. How to summarize in 2 sentences what I have said. Let me say this. I think we've seen that IP enforcement, and in particular remedies, are changing a lot in the current world. Things that were assumed to be settled and carved in stone are becoming to be questioned because of new realities that we see. And we have seen what is happening in the United States. We have seen that in Europe we can take certain initiatives. And we have also seen that that certain measures that we have implemented on the European level and then hope to be transposed on the national level, notably injunctions against intermediaries, were not always understood, and they're subject to their own national sediments and leads to a lot of non-harmonized practice in the member states. So we've heard a plea for harmonization of accessory liability, of injunction against intermediaries, of looking more into follow the money approach, and also maybe thinking broadly of what is happening in this landscape also in the United States as a learning example. So this would be my summary. Thank you very much.
Okay, hello everybody. In our second panel, we are dealing with the recent European trademark reform, and it was discussed both from the academic and practitioner's point of view. I would say there were many, many interesting points mentioned. For example, the changes in the fee structures and also the very interesting problem of trademark cluttering. We now have directive and new European trademark regulation in place, so it will now be seen how the directive will be implemented in each member state of the European Union, and then, for example, in a couple of months or years, we will then decide how the further harmonization has been developed. And it will also be very interesting to see how the cluttering problem or the issue will be tackled by the new measures which will now be enforced and are actually, for example, with the one fee for one class principle be so. That will be for our second panel.
Thank you very much. Ladies and gentlemen, the organization asked me to summarize what happened during the third panel. And that's a very difficult task for me, because how can I summarize in 3 minutes what has been said by the panel. It's almost impossible. We live in very interesting times indeed, and I'm not just referring back to the outcome of the elections in the United States, but also to copyright. There are so many legislative proposals on the table right now. I counted 5. On the table right now is the proposal for a regulation on the portability of online content services. On the table is a proposal for a regulation and a directive in the field of an exception for the blind, the visually impaired, or otherwise printed disabled persons. And those 2 instruments are there to pave the way to the ratification of the Marrakesh Treaty. The 4th legislative proposal is a proposal for a regulation that I personally would like to call the Online Broadcasting Services Regulation. And last but not least, there is a proposal pending that is about copyright in the digital single market. And that's not just it. There's more on the way. We are awaiting a new initiative by the Commission, initiative on the enforcement of intellectual property rights. And no doubt that will also be very relevant indeed for copyright. Now, the 3rd panel was, of course, very lucky to have as a keynote speaker Maria Martin-Pratt. She is actively involved in the negotiations and the drafting of these legislative proposals. And she gave us some background information about the proposals and where they stem from. So it was indeed very interesting to listen to her. Igor Gilya then, in his presentation, said that indeed there are some challenges for copyright with applying copyright in a digital environment, making copyright suited for new technologies, taking on board different consumer behavior, but he also reminded us that we should not forget about the legitimate interest of the right holders. We also listened to a very interesting presentation by Suzana Adamova. She went into some of the contents of the documents that are currently on the table. She dealt with the portability regulation, and she also dealt with the proposal for a directive on copyright in the digital single market. And she dealt with extended collective licensing. And that was particularly appealing to me, because in the Netherlands, I come from the Netherlands, and we were preparing legislation introducing extended collective licensing in the Netherlands. However, the Commission beat us to it. There's a proposal now in the directive, and we very much look forward to constructively contributing to the negotiations on that part. And last but certainly not least, we had Matthias Leisner. And he was very courageous, I must say, because he went into 2 of probably the most controversial parts that are in the proposal for a directive on copyright in the digital single market. He tackled the issue of the introduction of a press publisher right, and he also went into the value gap proposal. And he said to us that the legislator should be as courageous as he was by tackling those topics. And he said, well, if you really want to resolve the outstanding issue as regards those 2 articles, we should also take a look at the communication to the public right, one of the basic concepts in copyright. There's a lot of interesting jurisprudence rendered by the European Court of Justice. Some of these judgments fit easily within the European copyright framework, but other verdicts are more difficult, let me put it like this, more difficult to fit into the European copyright framework. And then he was referring to the GS Media case. So, a lot of work ahead. The discussions in our panel could serve as a very good starting point for the discussions that await us. And let me put an end to my summary here. I already took too much time. Thank you.
Thank you. Ladies and gentlemen, the panel 4 was dealing with European patent system and its future, and it's not easy task for me to identify the conclusions or summary, but trying to find a common ground, maybe I would identify one sentence only and underline it. We still are in the process of bringing the child to the born, and it's not an easy process for anyone, but there is a commitment for all stakeholders and the member states to overcome the first diseases and to make it the best we can. This is very general, but I would say the only possible outcome we can identify. And I would like at this moment to thank again Mihai Ficsor as a keynote speaker, the other panelists, namely Joachim Feldges, Alfred Radauer, Ms. Margot Fröhlinger, and Mr. Alexander Ramsay for their engagement and for very interesting discussion. I would say that we all felt fire inside the debate, so it was confirmation that everything was completely all right. So thank you all, and thank you for having you on board.
I'm sure it's all fresh in your minds, the last panel, which was very intellectually correct. Well, my proposals, my points are this. One, that the current proposal tries to strike a balance to make everyone happy. Not an easy task, because some of our very technical aspects, such as the TDM. Another thing is that mandatory exceptions are in conflict with the present acquis. And it was suggested that the optional exception should fall in line with the present acquis, and therefore it would be preferable that would be optional exceptions rather than mandatory. Obviously, the ECJ judgments are a very important source of the development of this proposal, and one has to take note of them very, very attentively. But one last final point. One has to look at this proposal not only as from a utilitarian side, but also one has to render and be careful and be also protective of both authors and performances. And this is, I think, encapsulates the proposal, the complex proposal of copyright, which in the coming months would be up for debate. But once again, I would like to thank everyone for this pleasant sojourn here in Bratislava, beautiful city, and obviously for the panels and the presentations they have made. Thank you so much.
Thank you very much. Ďakujem veľmi pekne. Dámy a páni, tak sme...
Ladies and gentlemen, so we tried to summarize everything. So though the gentleman said it was not task and I was not jealous about them, what's ahead of us is the lunch. But first I want to say thank you on behalf of the organizers, on behalf of the Ministry of Culture and the IPO of the Slovak Republic. Thank you for participating in the discussions, for accepting the invitation, for helping us finding the questions and answers. Those of you who are from abroad, I wish you a nice journey back home. If you stay for a few days, enjoy your stay. And those who are from Slovakia, enjoy Slovakia. There's not much we can do about it anyway. There's lunch in front of us, but before that, we could try and make a common family picture outside. We would make a picture in the courtyard. So could you please, just before lunch, walk to the courtyard and be directed by our hostesses and organizers if you don't know where to go. And I wish you all best. Enjoy your meal and see you again.